Well, hello, everybody. Thank you for tuning in today. Welcome to Sign for More Injury Funding, the podcast for all who want to learn about legal funding and its significance in personal injury, workers' compensation, civil litigation, medical malpractice, dog bites, and many other types of law practice domains. I'm your host, Laura, founder and CEO of More Injury Funding, the legal funding counselors with passion for law, medicine, legal funding, and heart for all suffering individuals. More Injury Funding is a sponsor, board member, or a business partner of this podcast, Georgia's Trial Lawyers Association, Academy of Truck Accident Attorneys, Georgia Association for Women Lawyers, or GAL, Sandy Springs Bar Association, Georgia Association for Paralegals, Atlanta Legal Aid Society, State Bar of Georgia, St. Andrew Rowing Club, and Georgia Hispanic Chamber of Commerce. In today's episode, I have a very special guest with me today, personal injury attorney Maggy Randels with Randels Injury Law LLC based in Atlanta, Georgia. Maggy is a trial attorney representing seriously injured plaintiffs across the state of Georgia. In today's episode, we'll dive deep into the topic of third-party claims pertaining to the work injury context. At the end of our episode, I have prepared a fun pop-up question for Maggy, so stay tuned in. Welcome to It's Time for More Injury Funding podcast, Maggy.
Thank you for having me, Laura. I'm listening to your list of everything you do. This is why I see you everywhere.
Thank you. So good to see you again. I love it. Absolutely. So tell us a little bit about your firm and what types of law do you practice on a daily basis?
Absolutely. So I am a personal injury trial lawyer, and I do pretty much every type of personal injury case that you can think of, except workers' compensation. So I handle a lot of auto claims, and I've spent a large part of my career doing that. That's really how I cut my teeth in the PI world, is getting into auto claims, not just, individual to individual, but I love handling cases involving commercial auto claims as well. So trucking, work trucks. I've sued a bus company before, groom transportation, like the airport transportation van, Uber, Lyft, rideshare cases. So I do auto in kind of every context you can think of. And that also includes pedestrian claims. I've handled a good number of those. Be very careful if you are a pedestrian, especially in Atlanta. It is not a great place to be, and those injuries can be very serious. And then on top of auto claims, I handle a little bit of medical malpractice, although not a lot. And I have a lot of friends I work with who are much more skilled at that than I am. So I like to work with them on those cases, but I still handle a few. I've done a good number of child injury claims. So playground equipment at summer camps. And then I've handled a lot of premises liability cases in all sorts of different contexts. So not just a slip or trip and fall, but also negligent security cases. And then, of course, the type of claim that we're here to talk about today, which is one of my favorites. So, and I call them third-party claims with respect to work injuries. So when you're hurt at work, you can't sue your employer, but you do have your workers' compensation claim. Mm-hmm. But lawyers like me, we can find people who are not your employer, so individuals or companies that have responsibility. And we'll get into this more, but it's a lot potentially bigger recovery and more complete recovery than the workers' compensation context.
That makes sense. And what steps would you say should be taken when pursuing a third-party claim in the workers or work injury situation?
Well, the first thing is to take care of yourself. And I think this is true in really any type of injury claim. Obviously, you want to make sure you're preserving evidence, but you're the first priority. So get your treatment and do that through the context that you have. So if you're hurt at work, follow the procedures for your workers' compensation. Most places are going to follow the rules, have the panel of physicians up somewhere. And so go to one of those physicians, get your treatment. But at the same time, if you're able, start by taking photos, figuring out what happened, how you were hurt. And then, most people regular people aren't going to be thinking about, oh, can I sue my employer? Can I sue somebody else? And you don't have to be thinking about that initially. But if you can take photos, make sure somebody makes an incident report, collects the evidence, that really sets everything up for a lawyer like me to come in and then try and figure out, is there somebody else who's not the employer who has fault here so that we can sue them?
So just preserve the evidence. Pictures and the reports are the main things to start with.
Absolutely. And if you're hurt by some sort of product, so if it's a machine, if it's a tool, anything like that, where there might be a product involved, because we might have to pursue a product liability claim, have somebody save that.
Okay.
Don't let it go, because if you're injured by something like that and we don't have the actual thing that injured you, that can make it really, really tough, if not impossible, to pursue a claim.
And could you give a couple examples of those tools or equipment?
Yeah. So if, for example, if you are working on a construction site and there is, it can be anything from, I've seen a table saw, if there's a table saw that you're cut by, have somebody save that, tell them not to get rid of it. If you don't do this immediately, we as lawyers can certainly, if we're called early enough, send out letters to preserve this type of information and material. But if you think of it, or if you're listening, or if you have friends who are working in this type of environment, tell them, save everything. So tools like table saws. If you're working with a drill and it injures you, if you're driving a forklift and there's potentially some malfunction with the forklift, make sure the forklift is saved and, not taken away and destroyed. I've seen things like, looking at a claim right now involving an imaging scanner. So try and get that preserved, or at least get photo and video of it. The possibilities are really endless, because as we all know, you can get hurt in a lot of different ways. And especially at work, there's lots of machinery, and it's not just construction sites. It could be anywhere.
Absolutely. So how do insurance companies typically handle these third-party claims in work injury cases?
It's tough, because people they're skeptical, because they think you have workers' compensation. How, that's it. That's supposed to cover you. So insurance companies for those non-employer entities are going to look at your claim skeptically. And the first thing that they're going to do is try and say that the entity we are suing is actually the employer, or is under the law considered the employer. Because the way it works, and so in Georgia, it's under our statutes, and they say when you're hurt at work, you have workers' compensation. And it doesn't matter if you were at fault or not, you're going to get paid for your injuries through workers' compensation. But that's a limited system. So it limits the doctors you can go to. It limits the amount that the doctors can be paid for certain treatments. There's no pain and suffering. It limits the amount of lost wages that you can get. So it's a good system in some ways, because it makes sure you're going to get some compensation regardless of whether you're at fault or not. But there's a lot more in the personal injury context, because we get pain and suffering. We get your full lost wages, not just the amount that's paid by workers' compensation. But at the same time, there are a lot of hurdles to jump through. So you can't sue your employer. You can't sue an employee of your employer. You can't sue another entity that has control over you. So insurance companies know that, and they're going to be scrutinizing these claims and trying to say, well, how can we get rid of this? How can we make it go away? So it's it's going to be very hard to handle this type of claim without a lawyer who is experienced in handling them, finding those entities, knowing how to navigate the different exceptions to what we call the workers' compensation bar. And then if you get past that hurdle of actually getting to pursue your claim against a non-employer company or person, then the insurance company is going to look for ways to do what's called apportion fault. So in Georgia, we get to a jury at the end of the day gets to apportion fault and decide, how much are you as the injured person at fault? How much is the defendant, the person we're suing, at fault? And then how much are other non-parties at fault? And that includes your employer. So insurance companies are going to look for ways to say that your employer did something wrong, that they didn't provide the right safety equipment, that they didn't provide you the right training. And so that's all evidence that we're trying to gather is, what did your employer do? Did they do something wrong? And then at the end of the day, figure out how to minimize that percentage that gets put on your employer, because every percentage of fault that is put on your employer, well, you're not going to recover that at the end of the day.
What would you say are common challenges that you and your injured clients deal with when it comes to third-party claims and work injury context?
I think
I know you mentioned a few of these.
Yeah, I think one of the biggest challenges, not from the insurance company perspective, but just from a practical perspective, is, like I said, the workers' compensation system is good. It provides you medical treatment, but it's also a system that is designed somewhat in the employer's favor. So because you're limited in the doctors that you can go to, and there's a workers' compensation claims adjuster that has to approve all of the treatment and decide what's related to the work injury, it can be a challenge to get the right treatment that's needed as somebody who's injured at work. And there's a balance there, because when you have workers' compensation that's paying for your treatment, you want to use that. It's advantageous to you because, first of all, it's provided to you. You're not having to pay anything out of pocket for it. And you're getting good doctors, often the same type of doctors that folks go to when they're injured in a car wreck or injured in any other context. But sometimes workers' compensation, if you have, let's say you have a shoulder injury and a back injury, well, workers' compensation might decide we're going to handle the shoulder first and the back can wait. And so that can be a challenge, because your shoulder's getting treatment, but you're still having pain in your back. And so you have to figure out how to deal with that and figure out a balance of getting the right treatment. So you have to be an advocate for yourself. And hopefully you also have a good workers' compensation lawyer to help navigate through that process. But I do think getting that treatment is one of our biggest challenges, is making sure that not only are you getting treatment, but you're getting the right treatment, and you're also getting treatment for all the injuries that you suffered. And then the other challenge we've kind of talked about is just that there are a lot of moving parts to these claims. There are a lot of potential people that can be sued, but there are also a lot of people that can't be sued. And so just making sure that you have somebody who knows how to do the research, how to look at, one common way that we can find a third party, especially if there's something wrong with the premises, the grounds, the location where this happened. Your employer might be entity ABC Incorporated, but the building or the land might be owned by ABC Company LLC. And so those are two different entities. And we might be able to sue the second one, but we have to be able to look at things like your paychecks and see who's paying you, look at the land records. So it's a challenge, but I really enjoy it. I think it's kind of a puzzle trying to figure out, who are the right people and how can we get them involved. And if they have liability. I'm not trying to sue people who aren't responsible, but if there's somebody responsible who's not your employer, we don't want to leave that claim on the table.
And you mentioned that, in situations like that, it's always a wise decision to hire a skilled attorney. And just to kind of summarize it, how can working with a skilled attorney help navigate the complexities of such a third-party claim in work injury situation?
I think even more so than in other contexts. Of course, if you're in a car wreck, you still want a skilled attorney because there are things that are going to be missed if you don't hire somebody, and insurance companies are going to take you more seriously. But in this work context, I'm not going to say almost impossible, but it's really tough to find everything that you need to find and manage all of the interactions that you need to without a skilled lawyer. And honestly, I think it's actually two skilled lawyers, because I am very familiar with handling these third-party claims and figuring out the puzzle that I talked about, but I don't do any workers' compensation, and I would feel uncomfortable doing it. So I work with workers' compensation lawyers who are very skilled at handling that part of the claim. And I don't know if there's somebody out there who does both. If they do, power to them. But I think actually that specialty and being able to focus on one type of claim in the work context is important. So hopefully you have a team of lawyers who are working in your favor. So you have your workers' compensation lawyer who can manage everything with the State Board of Workers' Compensation, totally different system than our courts, where you're going to be pursuing your third-party claim. And as a skilled lawyer, we can help, find those different entities, put the puzzle together, make sure that you're getting the treatment you need through your workers' compensation, and helping you navigate if there are some gaps in that workers' compensation treatment. We can make sure we find all the insurance policies, because at the end of the day, it's your insurance, well, not yours, but it's the entity's insurance that's hopefully going to pay for their negligence. And because there are so many moving parts, that's where we really come in and, take over and let you focus on getting better and not having to deal with the maze that work injuries can be.
Oh, very much so. All right. So what would you say are some key differences between pursuing a workers' compensation claim versus a third-party claim in a work injury dispute?
So the biggest difference is that workers' compensation is a no-fault system. So in the in the workers' comp context, you don't have to prove that your employer was at fault to recover. You just have to show that you were injured at work and that the injuries resulted from that, whatever happened at your job. So that makes it a lot easier. But then on the third party side, we have to prove that the other entity was at fault, so that they did something wrong, that they were negligent, or reckless, or more than that. But negligence is what we're going for. So we have to do that to prove that they're at fault and prove that you should recover from them. Otherwise, their insurance isn't going to pay. So that's kind of difference number one in just what you have to prove. And then the types of damages that you can recover are very, very different. So in workers' compensation, you're going to get your medical bills, but it's based on a set schedule. So there is a big schedule that says, if you injure your back and you have a surgery, there's a number that's set by the state as to how much that injury is worth. And then, as far as your wages, there's a certain percentage of your weekly wage that you get up to a cap. I believe right now it's $725 a week is the cap, no matter how much you're making. But in the third party context, so there's no set value on injuries. We as lawyers get to look at how much they're actually hurt, how much this has actually impacted your life. And we get to argue for full and complete compensation. So it's the full billed amount of your medical bills, not just how much workers' comp pays, but actually what the service is worth. It is the full amount of your lost wages. It's the full pain and suffering that you've incurred as a result of your injuries, which in the workers' compensation context, you're not getting any pain and suffering. So that's a really big difference in just the type of damages that you're getting, which makes sense because it's harder to pursue a third-party claim than a workers' compensation claim. So it somewhat makes sense that there are differences. Do I wish we could sue employers? Absolutely. That would, I think, make a lot of people's lives easier, but employers might not want to employ as many people. So there are trade-offs.
True that. You had mentioned that evidence gathering and documentation are crucial. And how so? How evidence gathering and documentation are crucial? What role does it play in the third-party claim in the work injury context?
So without evidence, we have no claim. As the plaintiff, we have what's called the burden of proof. Mm-hmm. So we have to come into court and bring the evidence to prove all the elements of our negligence claim and prove all the elements of your damages. Mm-hmm. If we don't have evidence, we're not going to be able to do any of that. I was working on a case recently, and very, very great client, but unfortunately, the claim didn't come to me until almost 18 months after the injury. And so there's very little I can do at that point to preserve evidence. We have what she has. We have medical records, we have statements from people, but there just weren't a lot of photos of what actually happened, the aftermath of the injury. This was a case involving some packaging of a product, and we didn't have that. And frankly, it made the case challenging because I couldn't look at something and say, here's what happened. I couldn't send actual materials off to an expert to have them analyze and figure out, here's what happened. So we were able to pursue a claim and it worked. But it would have been much easier if I had photos to say, here's the actual product, here's how it was set up on the job site, here's what it looked like. And honestly, the defense was able to use that against us because they're able to say, well, we think you're wrong, and here's what we think happened. That we think the product was set up differently than you do. And ultimately, we were able to settle the case. But if we had gone to a jury, that would have been a big risk because jurors, they don't want to be there. They're all doing their civic duty and they're doing the best that they can. But frankly, when you're on jury duty, you don't want to be there unless you're a lawyer like me. And please call me for church. I would love to go.
And believe it or not, I've never been called yet. I can't wait. I've lived in this country for 23 years. I hope one day soon, keeping fingers crossed.
But the jurors are doing their best, but really what they're looking for at the end of the day is, why are we here? And they're going to be upset at the party that made them be there. So if we're walking into court without enough evidence, without pictures, without a concrete description of what happened, my worry as a lawyer is the jury's going to be angry at me. And that anger at me, I have lots of cases, and I'm perfectly happy to take anger, and I tell clients that before their depositions all the time, let me get angry, let me handle this. But in front of a jury, if they're angry at me about not having evidence, they're going to be angry at you as the client. And that's going to be really harmful for your claim because they're not going to want to give you money if you're not even walking in with photos of what happened, with the actual materials. So that's why the more you can start from the beginning and gather everything, over gather evidence. I would rather, as a lawyer, sort through a lot of information and try to figure out what matters than only have bits and pieces, because I can tell a story from anything. And I'm going to be able, hopefully, to put a case together. I'm confident in my ability to do that. But why make it harder? Gather the evidence, put it together. And that's going to help you with an insurance company too, because at the end of the day, insurance companies are looking at risk.
Mhm.
They're looking at what's a jury likely to do. And if a jury is likely to award a lot of money because you have a lot of evidence and a lot showing that their insured is at fault, then they're more likely to pay out a good settlement. But if they're looking at and saying, well, what are they going to put up in front of a jury because they don't have any evidence, then it's going to be harder to get a good result out of an insurance company prior to trial. Not to say it can't be done. We can do it, but we'd prefer not to.
So what are, Maggie, some potential outcomes and settlements that can result from successful third-party claims in a work injury litigation case?
Well, honestly, it's extra on top of your workers' compensation payment. So some of you may have heard of a concept called subrogation, and that exists in the workers' compensation context. So technically, when your employer's insurance company pays out your workers' compensation, so your medical bills, your lost wages, they have a right to come back and get paid back for what they paid out. Except we have a really good law in Georgia that's called Made Whole. And Made Whole says that unless you are fully and completely compensated by your settlement, then your workers' compensation insurer has no right to come back after you for those additional funds. Another good reason to hire a good lawyer who knows how to deal with this, because it can be a lot, and often the workers' compensation insurance company will hire a lawyer to come and do what's called intervene. So they'll add themselves as a party in your third-party case, and we have to fight that battle as well. But at the end of the day, usually they're not going to be able to get paid back. So that your third-party claim is there to help you make up for what the workers' compensation system doesn't cover. Mm-hmm. So you're able to get your full billed medical expenses. You're able to get lost wages. You're able to get your pain and suffering, mental pain and suffering as well, so long as there's a physical injury, which usually if there's not a physical injury, I'm not going to be pursuing it. But it's a really great thing if you can find somebody who is at fault. And I say find, I'm not trying to pull somebody out of thin air, but figure out who might have been involved such that you can pursue this full recovery.
And how do legal regulations and statutes impact the eligibility and success of third-party claims in work injury context?
So this all starts from our workers' compensation statutes. And in Georgia, it's workers' compensation is what's called the exclusive remedy. So it's the exclusive remedy against your employer. That's what says you can't sue your employer if you're hurt at work. There are some exceptions to it. So there's an exception that says if there's an injury personal to you, then you might be able to sue your employer. And when I say personal to you, it's something like a sexual assault or an attack against you by a co-employee that's about something going on between the two of you. Things like that. There are some exceptions that allow you to pursue cases against your employer, but that's all set forth in the statutes. And then there's a lot of Georgia case law on it as well. So that's another piece of that puzzle. Can you actually sue your employer? But that's kind of few and far between. And then the statute also sets forth that made whole, the subrogation that we were talking about. So it all starts from the statute. When are you injured? We look at, you might be able to sue your employer if you're injured there, but you're not on the job. That's all covered by statute as well. So lots of different puzzle pieces to look at. And, every case is different. So you never know what might be out there and how you can figure that out. But you have to really look at it piecemeal and, walk through what potential claims there could be. Another interesting way that the regulations come into play is OSHA regulations. So the Occupational Safe and Health Administration, they have a lot of regulations governing workplaces, and those can come into play, especially with putting fault on your employer. So a lot of defendants are going to come in and say, hold on, OSHA regulated this, and there's an OSHA regulation that says when you're at work on this type of job site, you need a hard hat. And so if your employer didn't provide a hard hat, that might be a reason to put fault on your employer. Now, of course, your defendants are going to try and say that even if your head wasn't injured. So beware, because they get misused, but that's the type of thing that people will try to avoid being held responsible for their negligence in this context.
I love it. And what would you say, Maggie, are some strategies for maximizing compensation in work injury context when it comes to third-party claims?
I think the first one is to, and this might be a little bit of a controversial statement. I know some lawyers will say, well, let's not use workers' compensation treatment. It's a limited system. The doctors aren't as favorable to injury claims, but I'm actually the opposite. I say strategy one is absolutely use every bit of your workers' compensation treatment that you are entitled to, that is free to you, and it's getting you care immediately. So use that up, because you're likely not going to have to pay it back at the end of your case, which if you treat outside that system, you may have to pay it back. So that's strategy one. You use your treatment. But strategy two is, talk with a workers' compensation lawyer to figure out when makes sense to resolve your workers' compensation claim. Because sometimes with workers' compensation, you may want to resolve your claim earlier, because they may pay out for future treatment, and then you can decide what to do. But I leave that to you and your workers' compensation lawyer to figure out what makes sense for every individual case. And then strategy three is find all the people who are at fault. There's no penalty for suing more than one defendant if there's more than one defendant who did something wrong leading to this injury. So it might be, there's a cleaning company that came in and didn't clean the floors properly. But then there might also be a product, a tool that led to your injury. And we have to figure out, how does this work together? Do we sue them at the same time? But we want to find all those potential defendants who did something wrong leading to your injury. But it all starts from the beginning of making sure that you get your treatment, take care of yourself, because if you don't get that treatment and you aren't working to get better, that's really harmful to your claim. And hiring a lawyer who specializes in these types of claims lets you focus on that. So don't be afraid to ask for help. Don't think you can do it all yourself, because when you're hurt, there's so much going on, and don't think, well, I'm going to pay a lawyer to do this. It is worth it. We are worth it. And we're just here for you, trying to help you navigate these type of injuries and do the best that you can for yourself. And we're trying to do the best that we can for you as well.
That's so great, Maggie. Again, thank you so much again for talking with me about the third-party claims in the work injury context. I hope it was informative and educational for everybody, as it was for me. And as promised, I have one last fun pop-up question. You ready, Maggie?
Yes.
Okay. What is your favorite quote or mantra that you live by every single day?
That is a great question. I was actually sitting at a soccer game, and not really a quote or mantra, but something I say a lot is logistics, that it all comes down to logistics. And I think you might have heard that, through what I talk about today, that everything's kind of a puzzle. But I think, when we take a step back and think about how is this going to work? How do we put this all together? Think about the logistics of life, of a trip, of a case. So, but I was sitting at a soccer game and I saw Geodis was the sponsor, and their tagline is "It's all about logistics." And I laughed and I took a photo of it because, like multiple times I've been places like rental car lines, logistics. If they should, sometimes I think maybe I shouldn't be a lawyer and I should go into logistics, but I love what I do. So maybe, second career.
I was going to say that this would be your second hustle.
So logistics side hustle.
That's it. That's it. I love it. Steve, you just came up with a new name for a business. I love it. Can't wait to see it happening in real life soon. Again, thank you so much for watching and listening to this episode today. We had Maggy Randels with Randels Injury Law LLC. Ladies and gentlemen, I want to thank you all for listening and watching our episode today. For more tips and tricks on legal funding and personal injury related topics, follow me, download, like, subscribe to More Injury Funding. And it's time for More Injury Funding podcast on all social media platforms, including TikTok, Google reviews, Instagram, Facebook, Pinterest, YouTube, and also, of course, follow me on moreinjuryfunding.com for more information about legal funding. Until then, thank you so much. Be well.
Thank you, Laura.